So the first question when a client comes to your office should be, is it a US person? And I say it because a client may not be only an individual, but also a corporation, a trust, or an estate. And this question is not that easy to answer as it may appear from the beginning. So let's talk about individuals first. Who are US persons? US citizens and US tax residents. Now, US citizens, that's not a very complex category, although there are some complexities. For example, when we talk about accidental Americans, when a person was born in the United States, but never lived here, he spent his entire life outside of the United States, or when a person has one US parent and one non-US parent. But in general, it's not that difficult to verify if a person is a US citizen or not. US tax residence is a more complex issue because it includes green card holders, that is US permanent residents, substantial presence test. So basically people who were here for enough time to pass the substantial presence test, and people who declare themselves as US tax residents. Now you may ask, who in their right mind would declare themselves as a US tax resident? Actually, that happens quite often, and I can tell you that in many cases, people do that without even understanding that they declare themselves a US tax resident. For example, when you have one US spouse and one non-US spouse and they file a joint tax return, well, non-US spouse just declared herself to be a US tax resident. The second category of US persons concerns corporations and partnerships, basically business entities. The rule here generally, and I emphasize the word generally, is that any corporation or partnership organized under the laws of the United States or any of its 50 states is a US person. Trusts, more complex. In order for a trust to be a US person, it must meet both the court test and the US control test under the IRC section 7701A30E. I'm gonna overgeneralize here. Generally, if one of the trustees is a US person and the trust document allows for a US court to exercise jurisdiction over the trust administration, the test will be satisfied. That is, this trust would be a US trust. Both tests must be satisfied in order for the trust to be a US trust. And then the states. That doesn't happen very often in a foreign direct investment situation, but generally speaking, a US estate is any estate that is not described in section 7701A31. I provided the definition for you here. You can read it. Basically, it has to do with US source income and what is includable in the gross income under subtitle A. Now, the important thing to understand is that if you're dealing with a US person, you're not dealing with an inbound transaction. That is, this entire framework, tax framework that I'm discussing, it doesn't apply to US persons. You have to look at a different set of rules. And US persons are, by the way, are taxed on their worldwide income. If this is not a US person, then we deal with inbound transactions tax framework.